to welcome you all to today's webinar on overseas direct investment, new regulatory framework. Thank you all for joining in our journey and encouraging and motivating us in our knowledge sharing endeavors. Friends, RBI has revamped the regulatory framework of overseas investment and has issued a new regime with the purpose of ease of doing business for Indian entrepreneurs in the global market. The revised regulatory framework provides for simplification of existing framework for overseas investment and has been aligned with the current business and economic dynamics. All these developments are well as other updates will be discussed threadbare during the webinar. Today, we will discuss the key area, concept of overseas investment by Indian entity and resident individuals, overseas portfolio management, investment of a stake in foreign entity, reporting requirement and late submission fees, regulatory update in Company and Securities Law, and various other things in this. I have received already 20-30 questions relating to this, and we will discuss all these things today. We are extremely fortunate to have with us the galaxy of very eminent speaker for today's webinar. First, we have Mr. P.N. Prasad, who is ex-Deputy Managing Director, SBI, and has been the 37 years of experience in multiple fields of banking, with a specialization in corporate banking, project finance, infrastructure lending, debt syndication, international banking, risk management, trade finance, stress asset management, and resolution. And his knowledge and his experience will tell us today that what he sees these changes and how these changes will impact. Thank you very much, Prasad sir, for joining us today. Then Mr. C.D. Srinivasan sir, he is the retired Chief General Manager, RBI. He is stuck in a meeting and I hope that he will join, and whenever he will free, he will join us. Then we have Amit Gupta, PCS Insolvency Professional. He is a leading practicing company secretary in Lucknow and is actively actively engaged in knowledge sharing. Then we have Mr. Ankit Singh, is a partner and head of corporate affairs and compliance of corporate professional, has been experienced working last 15 years in corporate legal advisory, due diligence, acquisition, IPO, corporate governance, foreign exchange law, and setting up business in India. Then we have Mr. Manoj Kumar, is a partner head and transaction of corporate professional. He is a prolific speaker and his quote and comments are regularly carried in major financial release, e-papers, and business magazine. Then we have Ms. Sweta Agrawal. She is ACS in the Senior Associate of Corporate Profession and working in this area of the FEMA and the OD, overseas investment, and various other aspects of the RBI related thing. Friends, as you are aware that in India, we have seen that overseas investment is a very interesting topic, but sometimes there is a confusion because of the strict compliances and various aspects which sometimes the clarity is missing. Today, when the new law has come and the RBI is planning to give the simplification and the providing various opportunity, today we will discuss this. But before discussing the law, the bill changes and the other thing, I'll request first Mr. Prasad, who, as you are aware, that he's a Deputy Managing Director of State Bank of India. So he has wide experience. He has seen this journey. He knows the law. He has seen the problems of the investor and the inbound and outbound proceeds. So today we just discussed about this particular new law, new changes, and what is his micro view on this. Over to you, Prasad sir.
Thank you, Pawan. Thanks for the nice introduction, and a very warm good afternoon to all my fellow panelists as well as the participants. So first of all, let me start with a simple question. What will be in the minds of all of us? What is overseas investment? Why overseas investment at the outset? This is a question where when we think of a country of almost 140 billion people, And then we think, why should overseas investments are required, whether it's required or not. Yeah, overseas investments by Indian residents definitely enhance the scale and scope of business operations of Indian entrepreneurs. It enhances the scale and scope of operations of Indian entrepreneurs. We have seen a lot of Indian entrepreneurs going abroad, creating success stories. So there is a need for these Indian entrepreneurs to provide an opportunity to join the global investment platform. It also gives access to technology. It also improves the R&D and a wider global market. So when we speak of globalization in a larger scale, any country which has aspirations to grow its economy and scale of operations need to also permit its residents to participate in overseas investment. That is the simple reason why overseas investments are required for a country and why it is permitted. Of course, what has been happening in the overseas investment scenario has been that this has been permitted, and the problems what we had practically faced was the lack of clarity in some of these definitions, interpretations, implementations, and so on and so forth. So what is currently happening? Now, the Reserve Bank of India has come out with the Foreign Exchange Management Overseas Investment Regulations, and the Government of India has come out with the Foreign Exchange Management Overseas Investment Rules. Both these rules and the regulations have been notified on 22nd of August 2022, and it supersedes the existing overseas direct investment rules. So that is the biggest change which has happened, that the current regulation and the rules which has been announced last 10 days back is superseding the earlier overseas direct investment rules. And now it is basically known as overseas investment regulations. So what is the underlying need for these regulations or the simplification is that we are seeing the liberalization and happening as well as the ease of doing business. So this has been progressively being simplified to make it much more inclusive for the participants. So the major changes which are announced in these new regulations is that there is enhanced clarity with respect to various definitions. So we have been earlier having problems in finding out different definitions for different entities, different rules, different rules for definitions were there. So this is now more simplified. I'll come to it, a few of these things which has been simplified in the next couple of minutes. Then there is an introduction of the concept of strategic investor. There is a concept of strategic investor which was not there in the earlier regulations. This is also being brought out in this new dispensation. And the most important change which has come is that a lot of requirements for approval, the approval process has been simplified. For example, deferred payment consideration. Say, for example, you have got an approval or you are permitted to make an overseas investment, but once the commitment or approval is there, then there is no need for a further approval from Reserve Bank of India from the regulator, the Reserve Bank of India. So this was one thing which has happened, that there is a dispensing with the requirement of approval for deferred payment considerations. And it also permits investment or disinvestment by residents Indians under investigation. So there has been some reference to the Indians, resident Indians who are undergoing certain investment or disinvestment. They are permitted under certain conditions. Then issuance of corporate guarantee on behalf of second or subsequent step down subsidiary. This is also being dispensed with. Approval is not required. write-off of investments or disinvestment, that is also now being permitted. Then introduction of late submission fees, that for any kind of delays, there is an introduction of a submission of late fees concept. So as I mentioned, with effect from 2022, August 2022, RBI has combined the ODI regulations and the FEMA overseas investment rules into the new overseas investment regulations. So this is the major change which was brought out in the new regime. So let us look at some of the areas what has been, as I said, there have been certain definitions have been simplified. So earlier the overseas direct investments were permitted by either in a joint venture or on a wholly owned subsidiary. But under the new regime, this definition has been completely removed, and now it only talks about a foreign entity. So the concept of a joint venture or a wholly owned subsidiary under the new regime is named as the concept of foreign entity, which means an entity formed or registered or incorporated outside India, including International Financial Services City in India, that has limited liability and a limited liability company, a limited liability partnership, where the liability of the Indian resident is clear and limited. So that is what is the definition of a foreign entity. This has been much more amplified now, instead of knowing earlier the concept of a joint venture or a wholly owned subsidiary. Then there is the strategic sector. The strategic sector shall include energy, natural resources sectors, such as oil, gas, coal, mineral oil, submarine cable system, and startups, and any other sector or subsector as deemed by the central government. The restrictions of limited liability structure of foreign entities shall not be mandatory for entities with core activities in strategic sector. This is one other change which has been brought out, and the concept of strategic sector has been amplified. So the financial commitment, the next is a financial commitment by an Indian entity exceeding $1 billion or its equivalent in a financial year still requires the approval of RBI, even when financial commitment of entities within the eligible limit under the automatic route. As you know, a company can invest 4 times its profit if it has been profitable for 3 years, or 400% of its net worth. The net worth is as identified as under the Indian Companies Act. That is how the investment has been permitted. So the next important thing, as I had mentioned, is that the issuance of corporate guarantee on behalf of second or subsequent level of step-down subsidiary. So this was not earlier permitted in the earlier regime. So now in the corporate guarantee for a step-down subsidiary, it is permitted actually. So the another issue is that introduction of late fee that we had mentioned. The late fee structure is also given in the circular. RBI direction, the RBI's circular, which has been issued on 22nd. The certain other changes which has been brought out is mainly it also permits non-financial entity to invest in a foreign entity engaged in financial services other than banking and finance. So earlier this was a restricted area. Now a non-financial entity, an Indian entity which is not involved in a financial activity, can invest in a financial service activity other than in banking and finance overseas. Various reporting requirements have been simplified. However, ODI is still prohibited in real estate, gambling activity, or dealing in financial products linked to Indian rupee without RBI approval. So, all in all, if you look at the framework and if you look at the directions, it has been aimed to simplify the overall management of overseas direct investments. Of course, I'll stop it here because the other speakers also can delve deep into the subject. And maybe I will also join at the time for the questionnaire. In fact, I had seen some of the questionnaires. Some of these questionnaires are specific and focused replies are required. So let me stop it here and let me request the other panelists to make their opinion or views. And then when the question answer comes, I'll definitely join.
Okay. Thank you, Prasad sir. Thank you very much.
Thank you
for giving introduction and of the subject. The introduction from the side of the person who has done 37 years in this area is a very important word for all of us. Now, I will request Ankit Singhi to please give his presentation and tell us about the concept changes and various other aspects. And then Sweta will join Ankit.
So I will give run through the latest amendments in the Companies Act and Securities Law. Then Shweta will run through the presentation of changes in the ODI regulations.
Okay.
So if you can, Vivek, Shweta, you can put the presentation. So first slide. Good afternoon to all of you. Before we start to discuss and deliberate on the latest changes in the overseas investment regulations, as a practice, the first Friday of every month, we have a webinar where we discuss the key changes that happened during the last month or till the date of the webinar. So some of the changes which happened during the last month or till the date, till yesterday, we'll just discuss in the next 5 minutes, and then we'll straightforward go to the ODI regulations. So foremost changes with respect to company account rule, where the government has now mandated that backup of all books and accounts has to be kept, and even if they are kept at a plate outside India, shall be kept in a server physically located in India on a daily basis instead of a periodic basis. So even if the books of accounts are being kept outside India, they needs to be backed up on a daily basis in physical servers located in India. While it is important to note that in case there any data is generally backed up, it's backed up on real-time basis. So the only thing that one need to look into is the important thing is that now that backup has to be kept in a physically server located India, because the account rules allow you to keep books of accounts at a place outside India in cloud or some other software. And there was a requirement of summary returns information being shared to the head office along with the backup. Now, instead of the backup on periodic basis, periodic means, like, for example, if you're taking a backup on weekly or a monthly basis, it has to be taken on a daily basis and on a server located in India. So while doing technically, it won't be much of a challenge in terms of just changing the frequency of the backup. What needs to be changed most probably is with respect to the servers. If their backup is outside India, if the original data is outside India, it must be backed up at the servers located there only or some other jurisdictions of the world. But now it has to be physically backed up, and the details of the service provider has to be provided along with the other details that we file alongside the financial statements every year in Form AOC4. Next, Shweta. So this is a very key change that has been brought by the government of India, where they have now empowered registrar of companies to do physical verification of the registered office. So registrar, by giving a notice can schedule a physical verification of the registered office at any point of time. There no reasons as such has been specified as to on what cases and in which situations registrar can undertake such verification, but it can. And it can come and seek the verification in presence of two independent witnesses of the witness of the locality where the registered office is situated. He may carry the forms that have been filed alongside the INC 22 with respect to the registered office while you were opting it at the time of incorporation or selecting changing it thereafter. The registrar can seek the originals of those documents and will also take a photograph of the registered office along with the verification report that he will prepare and submit to the registrar of the companies. In case for any reason the registered office is not found operational and the inspecting officer feels that there is no such registered office, then he may submit the report and the registrar can take necessary action for initiating the process of striking of the company. For this purpose, necessary corresponding change has also been made in the strike off form, where they've added option strike off on account of business not being carried or registered office not being operational, covered in the next slide. So this is an important requirement. While it can lead to a higher degree of harassment from the registrar of the officers, or at times it will be difficult for you to ascertain whether that the inspecting officer who is coming has proper authority or not, can allow notorious people to use this as an opportunity to create fraud on other people in tier 2, tier 3 cities, where they can appear as an officer of the registrar of the companies to inspect the registered office. There are a lot of issues connected with it. And the consequences are also grave in case the office is not found operational. Then, as I mentioned, the registrar can initiate action for the striking of the company under Section 248. Shweta, next. So this is the similar amendment that I just talked, that they have also made relevant changes in the Form STK 5A, and a checkpoint has been provided that the company is not carrying any business or operations revealed after physical verification. I don't know how they can come to a conclusion that after physical verification, even if the registered office is not operational for any reason, that company is not carrying any business. It will be very difficult to establish for them and can lead to further litigations. In such cases, we have to see how this will be implemented practically and what will be the consequences in days to come. Shweta, move forward. So then, as there was alert on the MCA, or it was in know-how for a long period of time that MCA is working on a new phase that is called version 3 on MCA 21. While some of the part has been implemented towards the LLP forms, now the company forms related to the company under the Companies Act are also now being moved on under the new web-based form mechanism, where you have to fill the form on the web instead of the download PDF form, and then you fill it. These forms are more and so new versions have been notified. These forms are more and so the copies of the earlier forms, except the fact that now they will be available on the web-based. Going forward, while this has been a phase-wise implementation, in the first phase, these forms are being implemented. But going forward, I believe majority of the forms that we currently file will appear as a web-based form, and you have to download the PDF or then affix signature and upload it. So that would be the way to go. So post 31st August, these new forms were supposed to be introduced. So so government has issued necessary notification providing for the new form format in the relevant rules. Securities law next, Shweta. So important update is with respect to issuance of settlement scheme 2022. I think this settlement scheme has been basically introduced in order to deal with matter relating to LTCG, which are pending in very good numbers before the regulator. Manoj, if you can add some thoughts on this.
regarding this settlement scheme.
Yes.
So yes, so as we might everyone might be knowing that there are around 14,000 cases of financial irregularity in the capital market, where people have used capital market for wrongful capital gain or capital losses. That is alleged by SEBI, and these matters were pending before various adjudicating authorities of SEBI. But considering the high volume, it was very difficult for SEBI to handle those. Many of the cases went to SAT, and SAT also said directed SEBI that to consider whether there should be some settlement scheme for the same, so that the court is not burdened by these cases. So they came out with an earlier scheme of settlement where the penalty amount was very high, and because of that, the settlement scheme failed totally. So that time, I think minimum amount was around 5 lakh rupees. So that scheme got failed, and very few persons applied for settlement under that law. There was one another problem in that settlement scheme was that people have to accept the guilt. So acceptance of guilt could have led to other regulatory actions like under income tax scrutiny and all other things. So that the people were very much hesitant. Now a new scheme has been introduced as per the further directions of the SAT, and under this scheme, the amount is very, very low. It starts from 1 lakh rupees and goes up to 5 lakh rupees as one-time settlement, where even without accepting the guilt, people can get their such allegations consented by SEBI. So I think
this is without guilt matter is only with respect to matters relating to LTCG or for other
yes,
matters?
Yes, it is limited to those cases. Those have been, there are persons who have got the notice, show cause notices. So there are around 14,000 people who have got the notices. And so there are, in each of the cases, there are a number of transactions. So based on the number of transactions they have occurred, this settlement amount comes out. So for 1 to 10, 1 to 5, it is 1 lakh rupees, 5 to 20, it is around 2 lakh rupees, then and goes on up to 5 lakh rupees. So if they accept, it is a very structured kind of settlement process where you can log in and fill up your informations and accept, and whatever amount is coming, you just pay through that link and it will be settled. So it is more of a cleaning up process through which around 14,000 cases may be adjudicated, maybe removed from the system of adjudication process. So that is, I think, welcome move, and
thank you.
It will help to SEBI to fast track the other processes.
Shweta, next. I think this is the last. So last month, the entire listed corporate world was taken up surprise by a new requirement, which was intimated by the stock exchanges with respect to issuing a certificate as to the compliance of the structured digital database requirement under the PIT regulations for the quarter ending June 30th, and it was to be submitted within a defined period of time under the digital structured digital database requirement under the PIT regulations. Every company has to maintain such database in a structured form. There are characteristics which are linked with respect to the Shweta, last slide only. Characteristics linked with the SDD, like non-tampered audit trail, all these things need to be there. So there was a certificate that needs to be issued by all the compliance officers, and from this would be compulsory from next quarter to be submitted on a quarterly basis. I think on and before 21st of every quarter end, and it will also be accompanied by a certificate from a PCS as to that the compliance of SDD is being done along with that certificate, and companies have to file this information along with other quarterly compliances. Next, Shweta. Another important move by SEBI, because I believe SEBI was finding that there were a lot of insider trading violations by DPs, more so during the closure of the trading window. And so they thought that the best way to curb such trading is to curb freeze the demat account of all the designated persons during the course of the closure of the trading window. So from, I believe, 1st September, a specified class of companies initially will have to intimate the closure of trading window to the designated depository, NSDL CDSL, who will basis the depository list of the designated person that is already available in their records, which were filed under the requirement of system-driven disclosures. So the depositories will put a freeze on all these trading demat accounts connected with these designated persons during the course of the trading window closure, during which they cannot undertake any transaction in the securities of the concerned company, thereby completely removing any chances of any trade by any designated person during trading window closure, resulting in any violation. So I think it's a welcome move, and it will definitely, I think 99.99%, it will root out all the instances of violations by the designated persons during the course of trading window disclosures, because any transaction can only take in demat account these days, and if there is a freeze, and there neither can there be a debit, neither there will be a credit. So all transactions will be fully stopped, and I believe the compliance level will also increase in all the listed entities which were finding it tough to implement this restriction of non-trading in the during the trading window closure. And I think designated persons also find a sigh of relief, because a lot of them actually does this trading on account of ignorance. So they will also find them in a much better place. Next. So now Shweta, I'll ask you to take this forward.
Ankit has, so friend, as you are aware that every month of the first Friday, we cover all the changes. So whatever changes came in MCA, SEBI, we have covered. And now this is the biggest change has come in RBI regulation, the new overseas investment. Now we will discuss these things, and then we will take question answer from the public. Yeah, Shweta, please.
So Shweta will discuss the presentation as and when required. We'll discuss on specific issues during the course of the presentation.
Ankit, can I flag one issue on what you were discussing regarding the electronic mode? I think there is a lot of confusion with regard to how to decipher between the electronic mode when you will say it is to be considered as being maintained in the electronic mode or otherwise. Like a very crude example is somebody maintaining the books of accounts in a tally without ERP version, without having internet protocol, whether it is a maintenance of books of accounts in an electronic mode or it is still a physical mode. Because if you read Rule 3, then it requires you certain disclosures to be made in your form AOC 4.
Yes.
Now, maybe I'm not sure whether the person who is maintaining in tally will be able to give all these details or not. What is the industry practice? I just wanted to understand, because we are receiving
different approaches are being undertaken, and while you maintain this, in case of tally, while some disclosures can be possible, but some are not possible. And it is also important to note, Amitji, that in most of the cases, while we were maintaining in tally, in all these cases, data is generally maintained on your internal servers. Unless otherwise you are using a cloud version of tally, if you are using the localized version, the data is always stored on your internal servers only, not on any cloud. It's only some ERP packages where
I think
voice is freezed.
Yeah, Amit, we will cover these questions.
All right.
I will request Shweta, please start your presentation.
So good afternoon, everyone. So as stated that RBI has issued new set of regulatory framework of overseas investment with the purpose of ease of doing business and keeping in view the increased amount of global activity and interest of the Indian investors to go global. RBI, in consultation with central government, has came up with a new framework of the overseas investment regulations. So here, first let's understand that what was the previous framework and how RBI came up with these new framework. So in 2004, On 7th July, RBI issued the earlier regulations, the extent framework, and under that there were two things, regulations and master directions, and both were amended as on the basis of time-to-time basis. Now in 2021, RBI came up with a discussion paper, and under that it proposed certain changes in ODI regulations and ODI rules, and seek the suggestions and ideas of the general public to get to know that how the provision should be drafted in for the purpose of ease of doing business. Now, recently on August 22nd, 2022, RBI issued the new framework, that is the final ODI rules, ODI regulations, and ODI directions, stating the applicable provisions thereof. So here it is very important to know that the ODI rules, regulations, and directions, all the three documents are supposed to be read collectively in order to interpret any transaction and compliances thereof. So it is not, the harmonious interpretation will not be done if anyone will refer only the rules or the regulations or the directions. So all the three documents are required to be read collectively. Now, let's know that what exactly are covered under the ODI rules and ODI regulations. So under the ODI rules, RBI has specified the definitions, the concept of the overseas direct investment, overseas portfolio investment, acquisition of immovable property outside India, transfer of investments. So these concepts are covered under ODI rules, and under ODI regulation, financial commitment by way of debt has been covered. Obligations of in India, the reporting of. It shall be noted that why RBI has included acquisition of immovable property outside India under the provisions of overseas investment framework. So the basic purpose is that even if an Indian investor is acquiring any kind of immovable property outside India, that is treated as an overseas investment. That is why RBI has covered this regulatory provisions under the overseas investment framework, and earlier it was under the separate regulation. And about the overseas directions cover all the procedures as mentioned under the rules and the regulations. So now let's understand what is overseas investment. So overseas investment covers two things, that is the ODI, overseas direct investment, and overseas portfolio investment. So these are the two ways. And under these, there are two routes which are very important to know, that is the automatic route and the approval route. So either of the investment can be done under the automatic route or the approval route. So the central government approval will be required to be obtained by the Indian investor in case of ODI in strategic sectors or the geographies. And as stated in the initial, in the beginning of this webinar, strategic sector is a new addition into the overseas investment regulatory framework. Further, if any investor is willing to make investment under the jurisdiction of Pakistan, then also central government approval is required to be obtained before making the ODI transaction. Further, RBI approval is required in case the Indian entities are like reaching the limit of financial commitment, and this limit is under two parts. That is, first, the 400% net worth of the Indian entity which is making the overseas investment, and the total investment shall also be within the limit of $1 billion. So in any case, if the company is not breaching the limit of 400% of the net worth, but the amount is more than $1 billion, then the said transaction will be required under approval route. With respect to OPI, or the transactions which are mentioned by the authority under the provisions are covered under the automatic route, and all other transactions which are not mentioned out there explicitly, that will be under the approval route. So under overseas investment, this have basically three components: the ODI, summing up to debt and non-fund based facilities given to the foreign entities, plus overseas portfolio investment. So here it is very important to know that under the overseas previous overseas framework, ODI, OPI, the overseas investment was not used as a terminology. So here overseas investment means any investment in a foreign entity in any type of security or loan, either directly or indirectly, that will be treated as the overseas investment. And all the three components are required to be aggregated to come up with the total overseas investment. And the financial commitment, the limit which we spoke about in the last slide, that covers only the ODI and the debt and non-fund based facility, and it does not include the overseas portfolio investment. Further, it is important to know that whether the Indian investor can invest into any of the foreign entity. So the answer is no. RBI has stated that the foreign entity shall be engaged into a bona fide business activity. And bona fide business activity has been specifically defined by RBI under the provision stating that an activity which is permissible to be undertaken under the jurisdiction of India, under the laws of India, as well as the host country law. So the countries shall permit such business activity to be carried out, only then the activity will be treated as a bona fide business activity. And as mentioned that the earlier framework does not specify the three transactions. Now coming to the prohibition on the overseas investment. So whether our Indian entity is eligible to make investment in all the segments or all the sectors. So no, RBI has prohibited Indian entities to make overseas investment in the foreign entities which are engaged into real estate activity, gambling in any form. And this is a new addition to the prohibition segment. Plus the foreign entity which are engaged into the financial products which are linked to the Indian rupee without RBI approval. So these three segments has been prohibited by the RBI to be invested under the overseas investment route. Now it is also important to note that the earlier provision specifically prohibited Indian entities to make investment into a non-FATF or ISCO compliant country. But the new regulatory framework does not specifically mention this thing, and probably central government may in future will include the same if required. Now let's understand certain key terms which are added into the overseas investment regulatory framework. So the very first definition is about the control. So the meaning of control is right to appoint majority of directors, right to control management, right to take policy decisions exercisable by persons acting individually or in concern. So the exercise of control can be done directly as well as indirectly. The modes to undertake control are management rights, shareholders agreement, voting agreements entitling them equal to or more than 10% of the voting rights or in any other manner. So here it is very important to note that RBI has specifically mentioned 10% or more than 10% of the voting rights under the definition of control, which is actually creating certain complications in the interpretation and actually issues the practical situations. So
Shweta,
it is.
am I audible?
Yeah, sir, sure.
Yeah. I would also like to have intervention from Manoj and Amit. Can you go on the last slide?
Yeah.
So this new terminology of control that has been provided under the definition. So first of all, it is relevant to from the extent of only ODI regulations. But what is important that while they have taken the entire definition from what is provided in the Companies Act, but this requirement of the voting agreements entitling them to 10% is creating an issue that whether, because if you see in the overall context, this 10% equity holding or voting holding has been used in various provisions of the ODI regulations to restrict acquisition and to classify any acquisition as ODI and OPI. And so what needs to be looked into that if the three major points, that is majority of directors, control, management or policy decisions, is that the key criteria to establish control, and which can be other modes, or even the voting agreement of 10% individually without having all these three rights can also be considered as control, because if the first three are the key things, then whether I have 5% and I have these things, uh, whether that can be considered as the control or not is something that needs to be looked into. If you can go into the next slide, Shweta. So this is what is being mentioned, and why I am saying that even RBI seems to consider only 10% is this paragraph which I have taken and which we have taken out from the master directions, where they specifically includes which when they're talking about control, which includes the stake of 10% or more in any entity as per the ODI rules, the third point. So here they only use the stake of 10%. So it's not clear whether RBI wants to treat control in foreign entity by way of only 10%, because if that would be the case, would first it would be devoid of the internationally globally accepted practices of dividing control, and it will create or have far-reaching consequences for Indian companies which have to structure their overseas investments in case they have subsidiaries or they have investments which is in minority like 10%, 15% as in the majority stake, then they have to some extent rework the existing structure and look into it from a new perspective. So Amit
Ankit,
and Manoj,
yeah,
if you can
so
add.
Ankit, I think the background is that RBI has always in ODI law considered 10% as the threshold. Over that, they consider it to be a joint venture situation, and they have allowed, let's say, investment in such circumstances that there is some relationship of control. It may be partial, it may be a joint control, but there can be control only if it is holding 10% or more. So primary test is control, not the modes of the control. Modes of the control are a list which is suggestive list given. It is not the conclusive thing. The thing is control, whether or not it is coming through 10% shareholding or through some agreement or otherwise. Whenever there is an agreement, there can be a control situation, and in that case, it will be considered to be a controlled entity or a company entity under control where investment can be made. So that is the threshold. Minimum threshold has been kept as 10%, which is, I think, earlier also indirectly reverse situation also it is given.
The question is just having 10%, 10% in any foreign entity or foreign entity having in its own downstream investment, will that be equivalent to control?
No, that is, I don't think that can be a thing that if you are holding 10%, then it becomes control situation.
Because if you refer this paragraph, it specifically only refers of stake of 10% or more. So there is some amount of vagueness that is there. Either it should be both.
That is mainly to distinguish between a joint venture kind of situation and a portfolio investment situation. So if you are acquiring shares as a portfolio investment, you are not trying to be part of the control group of the company, then it is not ODI, it is OPI. So that distinction they wanted to make, and that's why they have kept this threshold of 10%.
Amit, you have any views?
I think Amit's connection is
okay. Let's move.
Yeah.
Okay, so the next important terminology included into the overseas investment framework is about the foreign entity. So RBI has defined the same and have stated that any entity incorporated or formulated or registered abroad, incorporated in the IFSC, that is International Financial Service Center, or the unincorporated entities with the core activities into the strategic sectors are included under the definition of foreign entity, subject to the limited liability of the Indian investor. So here, limited liability hereby refers, as stated, refers to the limited and clear liability of the Indian investor into the foreign entity. Further, under the strategic sector, an exemption has been given with respect to the provision of the limited liability. And it is important to note that strategic sector has been included into this regulatory framework, and it includes the energy and the natural resources sectors such as oil, gas, coal, mineral ores, submarine cable system, and startups, or any other prescribed sector. Into the extent provision, that is the previous regulatory provision, only the oil sector was specifically mentioned under the framework, and RBI has included the other sector with the purpose of widening the strategic sector investment scope. The next terminology is about the step down and subsidiary and the step down subsidiary. So subsidiary and step down subsidiary is to be determined only in respect to the foreign entity, and it shall mean in which the foreign entity has control. So any subsidiary or SGS in which the foreign entity has control will fall under the category, and such subsidiary or step down subsidiary shall also comply with the structural requirement, that is the requirement of having a limited liability. And here also RBI has given the exemption from the strategic sector. However, through this definition, there is one challenge. So by mere 10% of voting right, that will result to the control, and that will result into the numerous subsidiary or step down subsidiary and reporting thereof by the Indian entity. So there is a challenge under this definition. And this is with respect to the challenge which I have spoke about. So with the new definition, a lot of foreign entities under the current structure of the overseas investment by an Indian entity may become the subsidiary of an Indian entity. And from the Indian entity context, the foreign subsidiary still needs to be defined in the manner provided under Companies Act, that is for an Indian entity. If it holds more than 50% of the stake in a foreign entity, then only foreign entity will become the foreign subsidiary of the Indian company. So let's understand this by an example. So XYZ Limited is an Indian company which is holding 51% stake in YPTE company, which is a foreign entity. So here YPTE becomes the subsidiary of the XYZ Limited, that is the Indian company, as Indian company is holding more than 50% of the stake. Further, YPTE is holding 15% of stake in Z Inc. And by having more than 10% of the voting rights, Zinc Inc. is under the control of YPTE. Thereby, YPTE becomes the subsidiary of the Indian company, and Z Inc. becomes the step-down subsidiary of the Indian company. Now, in case XYZ Limited just hold 25% into the YPTE Limited. So here, as the amount of investment is less than 50%, the YPTE Limited foreign entity does not become the subsidiary of XYZ Limited, that is the Indian entity. Thereby, being even having 15% of stake in Z Inc., YPTE Z Inc. does not become the step-down subsidiary of the Indian entity. So here it is very important to note that the definition of subsidiary as per the Companies Act is also to be taken into consideration along with the control in order to determine subsidiary and step-down subsidiary of the foreign entity. So now, till now we have spoke about the overseas investment provision. Now, particularly we spoke about the overseas direct investment regulatory framework, which is one of the component of OI. So it means that ODI means investment by way of acquisition of unlisted equity capital, or by way of subscription to MOA, or by way of investing 10% or more than 10% of the paid up capital of a listed foreign entity, or investment by way of control, where the investment is less than 10% of the paid up equity capital of the listed foreign entity. So last 2 points are the new additions into the ODI definition, and through which even into the listed company, the Indian companies are making investments subject to they are having more than 10%. Now, it is very important to note that once an ODI will always remain the ODI. For example, if an Indian company has acquired 12% of paid up capital in a listed foreign entity, and later on it gets down to 5%. So whether that will remain under the category of ODI, or we have to recategorize the same. So RBI has specifically mentioned that no recategorization is required to be done. And once you have categorized an investment as an ODI, that will remain under the same category. So now let's know that what are the modes of investment through which Indian entity can make the ODI. So the very first investor under the ODI segment is our Indian entities, and they can invest by way of subscription to MOA, acquisition of equity capital, acquisition by way of bidding, tender route, right issue, bonus issue, capitalization of dues, swap of securities by any way of scheme of arrangement or merger, demerger, amalgamation, or they can even invest under the foreign entity by way of other than equity, that is debt, guarantee, pledge, and charge. So here we'll speak about the limits under which ODI can be made by the Indian entity. So as we have I have mentioned earlier also, the overall limit of the financial commitment is up to 400% of the net worth as on the date of the last audited balance sheet, read along with the total amount of investment up to USD 1 billion. So both the conditions, both the limits are required to be complied with simultaneously. Now,
just little bit louder, you please speak.
okay. Oh, is it fine now? I hope.
Yeah.
So now, with respect to the financial commitment limit, RBI has given exemption to Maharatna, Navratna, Mini Ratna, and subsidiaries of these entities, and it has stated that if these entities are making ODI in the strategic sectors, that is the foreign entity which are engaged into the strategic sector, then there will be no limit with respect to the financial commitment. Further, they have even liberalized the they have even prohibited that if the Indian entity have made any kind of delay into the reporting, then it is not eligible to make any further financial commitment into a foreign entity till the regularization of delay in reporting. So this has been added into the segment of prohibition. So now coming to the specific sectors in which Indian entities are allowed to make financial commitment. So the very first sector is Indian entity which are eligible to make investment into the financial sector. So Indian entity which are itself engaged into the financial sector are eligible to make investment in a foreign entity which is engaged into a financial sector. And the Indian entity are required to comply with these three conditions in order to make the investment. The very first condition is the net profit. The Indian entities are required to have at least 3 years of profit, the 3 preceding years of net profit. The other condition is that it shall be regulated or registered with the financial service regulator in India. And the other condition is approval from regulator in India as well as the host jurisdiction if required. So here one liberalization has been given by RBI. Earlier what was mentioned that approval from the regulator of India as well as host jurisdiction was required, and RBI did not exempt it in case of host country is not having any law with respect to regulations. So here RBI has exempted this thing that in case host country is not having any kind of regulation with respect to the financial sector, that is the company is not required to be regulated by the regulator, even then the Indian company is eligible to make the investment. Here it shall also be noted that one of the conditions which was earlier mentioned into the provision, that is compliance with the prudential norms relating to the capital adequacy, the same has not been mentioned into the current regulatory framework. And seeing to the COVID period, RBI has given an exemption to the Indian entities and have stated that if in any case, due to the COVID, in financial year 2020, 2021 and 21-22, that is the COVID period, if Indian entity has incurred any kind of losses, then they can leave these 2 financial years to be included into the criteria of net profit during past 3 financial years. So this is a very important exemption given to the Indian entities. So now RBI has even come up with a new provision allowing Indian entities which are not engaged into the financial sectors, and it has allowed those entities to make investment into a foreign entity engaged into a financial sector and have widened the provision, like have widened the number coverage of the overseas investment in which the Indian entity can do. So here the conditions are, the very first condition is the same, having the net profit for past 3 financial years. And here also RBI has given the exemption from the COVID period. The next condition is the Indian entity which is not engaged into a financial sector is not eligible to make investment in a banking sector. That is the foreign entity which is engaged into a banking sector, as well as the foreign entity which is engaged into an insurance sector. Further, here, for respect of the insurance sector, RBI has given an exemption and has stated that an ODI in general and health insurance can be done if such insurance business is supporting the core business activity of the Indian entity which is undertaken into the overseas jurisdiction. So let's understand this by an example. So an Indian entity which is doing business overseas is engaged into a business of medical or hospital, and they want to take in health insurance, like they want to invest into a company for an entity which is engaged into a health insurance. So here that overseas investment is going to support the core business activity, that is the medical or the hospital business of the Indian entity. So thereby they are eligible to make the investment into the insurance sector, that is the health insurance sector. And the other example through which we can understand is that if the companies Indian companies engaged into the motor vehicle segment, then they can invest into an entity, foreign entity, which is under the general insurance segment, as the same is going to help the company to undertake the business overseas. So here, as we have used the terminology foreign entity engaged into a financial service sector. So how we are going to define this? So here it is, RBI has said this thing that if an entity engaged into an activity which can be carried out in India only post registration with or regulated by a financial sector regulator in India, then that service activity will also be determined. That criteria can also be used to determine that whether the foreign entity is engaged into a financial service activity or not. And who are the financial service regulator in India? They are RBI, SEBI, IRDA, PFRDA, NPH, NHB, or any other regulator as specified by the central government for conducting the financial service activity. So here RBI have came up with a provision with respect to Indian entity into the startups. So earlier also there was a provision with respect to startup. However, no specific provision was mentioned, and RBI has permitted ODI and startups recognized under the law of host country subject to investment shall be made only from the internal accruals of the Indian entity or its group company in India, meaning thereby the Indian entities can only invest into the recognized startups of the host country, plus they are supposed to use only their internal accruals or the internal accruals of the group company, thereby no borrowed fund can be utilized. Here, there is one challenge which Indian entity may face, that they may need to give evidence regarding the status of the foreign entity as a recognized startup to the AD banks before AD bank are allowing the overseas investment. So this can be a challenge faced by the Indian entities out there. Now, one more segment, that is the IFSC, that is the gift city. ODI has been allowed under this gift city also by the Indian entities, and RBI has stated certain conditions. So the very first condition which is required to be complied by the Indian entity to make investment in IFSC, that is approval of financial regulator wherever applicable. And here RBI have added a timeline for the financial regulators to approve that application or to reply on that application within 45 days. And if the same has not been done by the financial regulator, then RBI will treat that particular application as a deemed approval and will allow the Indian entity to go ahead with the overseas investment. The other condition is that a non-financial sector Indian entity which is not complying with the net profit requirement, that is the net profit in the previous 3 financial year. So that particular company is also allowed to make investment in the IFSC segment. The last one is the Indian entity may also make contribution to an investment fund or vehicle set up into IFSC, and that particular investment will be treated as OPI. Thereby, that will not fall under the criteria of ODI, that shall be treated as OPI. So what is the overall purpose of RBI to make IFSC, like to allow overseas investment into IFSC? So the purpose is only to make the IFSC, that is the gift city, a vibrant place for investment and increase the amount of investors out there. So with respect to the overseas investment, it is very important to know that at what price or at what valuation the acquisition or ODI can be made. So here RBI has liberalized the provision. Earlier there was the criteria which are required to be complied with. However, they have simplified it and have stated that investment shall be in compliance with the arm's length price, plus the valuation shall be done as per any internationally accepted pricing methodology. Here also, RBI have asked the AD banks to pass a board-approved policy with respect to this valuation requirement so that they can verify that the valuation has been done in compliance with the provisions. Further, in case of overseas investment, which is undertaken by way of scheme of arrangement, which is approved by the concerned competent authority, in that particular case, no separate valuation report is required and ODI can be made as per the pricing, which is approved by the corporate competent authority under this scheme. So there the scheme pricing can be utilized in order to make the overseas investment by the Indian entity. So what was there under the previous regulation? So under previous regulation, RBI created two segments, that is the ODI more than 5 million, where the valuation from the registered merchant banker in India was required to be obtained, or from the registered investment banker or merchant banker which are registered outside India was required to be taken. And for the cases where ODI was below $5 million, then in that particular cases, valuation report from the CA or a certified public accountant was also can also suffice the things. Now coming to the very important aspect, that is restructuring of foreign entity. So if in any case a foreign entity is incurring losses, then Indian entity will require to restructure them. So RBI have kept that point into the mind and have allowed Indian entities to make restructuring of the foreign entities. So earlier also there was provision. However, RBI has liberalized those provision in order to bring ease of doing business into the whole scenario. So there are two conditions which are required to be complied with. The first condition is that foreign entity shall incur loss from past 2 years as per the last audited financial statements, and the diminution shall be the subject to the total value of outstanding dues not exceeding the proportionate amount of accumulated losses after restructuring. So these two conditions are required to be complied with before doing any kind of restructuring of the foreign entity. Now coming to the valuation perspective of restructuring. So valuation at arm's length basis by registered valuer or certified public accountant shall be obtained in case the diminution is of the amount, the diminution where the amount of original investment is more than $10 million, or the diminution exceed 20% of the total value of outstanding dues towards Indian investors. So in these two particular cases, valuation at arm's length basis shall be obtained from the valuer. Here, what was the earlier provision? So earlier, RBI created certain limits that the listed company can write off up to 25% under automatic route. Unlisted company was allowed to do write-off under up to 25%, and that was under the approval route. That is, unlisted company was required to obtain approval from the RBI. And like foreign company in which the restructuring is proposed to be done, Indian company shall have at least stake of 51%. So there were certain limits and conditions which was supposed to be complied with, and RBI has done away with these conditions with the purpose of making ease of doing business. So now RBI has came up with a new provision with respect to no objection certificate, and through this provision RBI has allowed the Indian entities who has an account appearing as an NPA or is classified as a willful defaulter by any bank or any Indian entity who is under the investigation by financial regulator, CBI, Enforcement Directorate, or SFIO, they can make ODI. However, they have to obtain a NOC, and that shall be obtained from the concerned lender bank or the regulatory body or investigative agency, and the NOC shall be adverse to the AD bank with an endorsement to the applicant. So RBI has came up with this provision and allowing these type of Indian entities to make overseas direct investment. So it is very important to know this thing that earlier RBI was seeking these NOCs. However, that was done by the RBI itself. However, now RBI has specifically mentioned this condition as a prerequisite for the investor to go with the to go to these regulatory bodies and obtain a NOC and address the same to the AD bank. So now here we come up to the round tripping provision, which is very important. And it shall be noted that in the previous ODI framework, RBI prohibited Indian entities to make investment in a foreign entity which is having direct or indirect investment in India, or an Indian entity to set up a subsidiary in India through its foreign entity, that is the foreign JV or wholly owned subsidiary under the automatic route. So these kind of investment, that is the round tripping, was not permitted by RBI, and this provision was mentioned only into the FAQ and was not into the mainstream regulations and the master directions. So RBI has done away with these conditions, and because it's very common for the companies to have subsidiaries in order to take business. So RBI in the new ODI rules have prohibited the Indian entities to invest in a foreign company that has invested or invest into India directly or indirectly, resulting in a structure with more than 2 layers of subsidiary. So they have allowed the investment up to 2 layers of subsidiaries. And it shall be noted that this restriction shall be applicable only when there is an inward remittance in India. So now let's understand this provision by way of an example. So XYZ Limited, an Indian company, holds 51% of stake into YPTE Limited, thereby making YPTE Limited a subsidiary of the Indian company. YPTE Limited is holding 60% in Z Inc. and 70% in XPTE. We shall note that that XPT, Z Inc. and XPT, all the three companies are the foreign entity. Thereby, there is no restriction, that is the number of layers. Because RBI have stated that here that investment or that foreign entity has invested or invest into India directly or indirectly. So as in first example, there is no investment in India. This structure is permitted. Now let's come to the other example where the structure is not permitted actually and the foreign entity have investment in India. So the first company XYZ Limited, being an Indian company, holds 51% in YPTE Limited, and YPTE Limited holds 51% of stake in ABC Limited company. So here ABC Limited company is an Indian company and ABC Limited is holding 75% stake in another Indian company, that is A Limited. So here the level 1 company is YPTE, level 2 company is ABC Limited, and A Limited is the level 3.
Shweta, your voice is Ankit, can you just cover up this part?
Yeah, so this is important provision, and what is not clear in this provision is the restriction with respect to the 2 layers of subsidiary that is provided in the regulation or rules is with respect to which entity, whether it has to be checked from the Indian entity or from the foreign entity in which the Indian entity intends to make investment. If that Indian entity has more than 2 layers of subsidiary in India, whether that restriction will trigger or the 2-level subsidiary has to be checked from the level of Indian entity. And it is also, yeah, Shweta, you can.
This category layering has not been defined specifically by RBI and thereby creating an ambiguity into the interpretation that whether the layer of subsidiary are supposed to be checked from the Indian entity or from the foreign entity.
Okay, we can move.
Okay, so this is the whole procedure of the round tripping, the provision of round tripping, and it shall be noted that RBI have exempted the certain Indian entities from this prohibition of investment resulting into structure with more than 2 layers of subsidiary. So RBI has allowed the banking companies, NBFCs, investment companies, government companies, and IFSC segment companies to make investment, that is to make ODI, even if that is creating the structure of more than 2 layers of subsidiary. So these companies, being the investment company, has been permitted by the RBI to carry on with the ODI. We have till now spoke about the ODI by way of equity made by the Indian entity. Now, Indian entities are also eligible to make an ODI by way other than equity, that is debt guarantee, pledge or charge. So these are also the modes other than equity which are allowed to be undertaken by the Indian entity. So with respect to this, the conditions are required to be complied with by the Indian entity. And the very first condition is that the Indian entity shall be eligible to make ODI. The next condition is that the Indian entity has made ODI by way of equity in the foreign entity. And the other condition is that the Indian entity has acquired control in such foreign entity at the time of making such FC, that is at the time of making investment by way of debt, guarantee or pledge or charge. So these conditions are required to be complied by. The next, now we'll speak about the debt particularly. So here in order to make ODI by way of debt, execution of a loan agreement which clearly specifies rate of interest which is charged at the arm length basis is required to be executed. The other condition is no loan shall be lent directly to the step down subsidiary by the Indian entity. So in which an Indian entity has control through the foreign entity. So it cannot lend directly to the step down subsidiary. So why next is
Ankit, please cover. You cover. I think Sweta ka phone. Ankit.
So the Shweta was discussing the provisions with respect to overseas investment through debt and other modes. So there are various modes of guarantee that can be provided by. Yeah, Shweta.
Yeah, so we are coming to the mode of guarantee. So there are the types of guarantee which has been permitted by RBI. So corporate guarantee, performance guarantee by the group company, personal guarantee by the resident individual, and the bank guarantee backed by a counter guarantee collateral by the Indian entity or its group company issued by the Indian entity. So these kind of guarantees can be issued. And when the guarantee is issued by the by group company, so here the determination of holding company, subsidiary company shall be done as per the definitions mentioned into the Companies Act, that is of 51% stake at least, and the corporate promoter group also. Here, certain liberalization or certain notes has been issued by RBI that the guarantee shall not be open-ended. The financial commitment shall include contribution by way of resident individual. So it means that in case personal guarantee is issued by the resident individual promoter, then that guarantee shall form part of the financial commitment of the Indian entity. However, in case the guarantee has been issued by the group company, then that guarantee cannot form part of financial commitment of the Indian entity, and that shall form part of the financial commitment of the group company independently. Further, the rollover of guarantee shall not be treated as new guarantee. This was also there into the previous provisions. However, RBI has liberalized the condition and they have reduced them and have stated that the amount shall not exceed to the original guarantee in any way. So these are the types of guarantee through which ODI can also be made. So now coming forward with the pledge or charge, that how Indian entity can do ODI by way of pledge or charge. So Indian entity may in favor of the AD bank or the public financial institution or the overseas lender, they can pledge the equity of the foreign entity or its foreign subsidiary, step down subsidiary. The next one is that they can create charge by way of mortgage, pledge, hypothecation, or any other identical mode on its assets, including group companies' assets. They are also allowed to create charge on the assets of the foreign entity or its foreign step-down subsidiary in favor of the AD bank or the public financial institution. It shall be noted that the pledge or charge created for fund-based facilities for Indian entity, then the same can be also issued to the SEBI registered debenture trustees. So apart from the AD bank or PFI or the overseas lender, then the pledge or charge can also be created in favor of SEBI registered debenture trustee. Further, here it shall be noted that the condition of financial commitment by way of pledge or charge in the extent extent regulation and the new regulations remains the same. However, in the new regulation, RBI have given more clarity over the calculation of the financial commitment, and they have mentioned a condition that the loan or facility given to the foreign company shall be utilized only for the purpose of core business activity of the foreign entity, and it shall not be utilized in order to make investment back into India. RBI have also stated that where the facility has been availed by the Indian entity for itself, then the value of pledge or charge shall not be reckoned towards the FC, that is the financial commitment. Now we'll also speak about the ODI by the resident individuals, and the modes are ODI without control in an operating non-financial sector, foreign entity having no subsidiary or SDS, right issue, bonus issue, capitalization, merger, demerger, or any type of scheme of arrangement, gift, inheritance, sweat equity share, ESOP, minimum qualification shares for holding. So here RBI have clearly created the provisions with respect to ODI by the resident individuals. So what are
one small point that now, which was not the case earlier, if an individual resident wants to invest in any non-operating company outside India, first of all, that is not allowed. And in case of operating company, an individual making investment is not having control in that company, then that company cannot have any subsidiary or step down subsidiary. So in case it wants to invest in any company in which he doesn't have control, and that company has pre-existing subsidiary or SDS, or want to have a subsidiary or SDS post acquisition, then it cannot be done. It is only possible when the Indian individual can be said to be controlled. This is a very important development.
Right. So now coming to the limit, like the limit total commitment which can be made by the RI, that is under the liberalized remittance scheme, and the resident individuals are permitted to make investment up to 2.5 lakh USD per financial year. And as stated by sir, these are the conditions that the RI are absolutely prohibited to make or hold ODI in a foreign entity that has subsidiary or step down subsidiary, even that the individual has control into the foreign entity, or ODI made without any control in a foreign entity that subsequently acquires step down subsidiary or SDS, then such RI shall not acquire any type of control in such entity. Further, RBI has also exempted the RI to make investment by way of inheritance, sweat equity, ESOP, and minimum qualification share in the foreign entity. And through these modes, RI is eligible to make investment in a foreign entity which is engaged into a financial service sector, or any financial or any foreign entity which have subsidiary or SDS where RI has control. So exemption through these mode has been given by the RBI to the resident individual. Now, we shall note that what kind of ODI will be treated as OPI in case of resident individual. So if the acquisition has been made by sweat equity, minimum qualification shares, ESOP, which is overall aggregating to less than 10% of the equity paid up capital of foreign entity without any control, then this type of ODI will be treated as OPI. And if the investment in a foreign entity by the resident individual is less than 10%, then that shall also be treated as OPI and shall not be treated as ODI. Now, as stated previously, for in case of ODI by the Indian entity, RI are also permitted to make investment in IFSC, and that conditions still remains the same. That is, the approval from the financial regulator shall be obtained if required, and ODI in IFSC except banking and insurance sector can be made if such entity does not have any subsidiary or step down subsidiary where the RI has control. Now, it shall also be noted that RI are also permitted to make investment in startups, and that can be done through the own funds. That is, no investment in startup which are there into host country and regulated by the laws of the host country can be made through the borrowed fund. Only own fund shall be used. The pricing guidelines and the no objection certificate, which was specified under the section of ODI by the Indian entity, remains the same for ODI by the resident individuals. Now, the other type of investor under the ODI category, that is the registered trust and society. The investment can be made by them under the approval route, and the registered trust and society shall be engaged either in the educational route or they have set up hospitals in India. These trust and societies are permitted to make investments subject to compliance with these conditions. That is, the foreign entity shall also be engaged into the same business in which the trust or society is engaged. The trust or society shall be in existence for at least 3 financial years. The trust deed shall be executed and approved by the trustees. Approval from the trustee shall be obtained in case of trust is making ODI, and in case of society is making ODI, then MOA rules or bylaws of the society shall permit ODI, and approval from the governing body, council, managing or executive committee shall be obtained. Then the special license or permission shall also be obtained from the concerned authority and to be submitted to the AD bank. So these conditions are required to be complied by the trust or society for making the ODI. The NOC in case of trust and society, the conditions are still the same as specified into the Indian entity segment. Now coming to the new provision, that is the overseas portfolio investment. So RBI has come up with this provision and has specifically created the provision into the overseas, the new framework to provide the clarity. So OPI shall mean investment in a listed foreign entity other than by way of ODI in foreign securities, unlisted debt instruments, derivatives or commodities, or any security issued by a person resident in India, which is not who is not an IFSC. So these instruments will not be form part of OPI. So RBI have given the clarity for both the Indian entity and the resident individual. So the very first investor under the OPI segment is the listed Indian entities, and the limit for the Indian entities to make investment under the OPI segment, that is up to 50% of their net worth as on the date of last audited financial statements. Now, the listed Indian companies have been permitted to make OPI even by way of reinvestment. And here, what does we mean by reinvestment? So, reinvestment means that OPI sale proceeds are exempted to be repatriated into India as long as such proceeds are reinvested within the specified time limit. So, if the Indian entity is making reinvestment of the sale proceeds of the investment made earlier, then they can do so, and that will be categorized under the OPI. Even now, unlisted Indian entities are permitted to make OPI. In the previous ODI regulation issued by RBI, there was no such provision and only listed companies were eligible. Now, unlisted Indian companies are also eligible, and the limit remains the same, that is up to 50% of the net worth as on the last date of audited financial statement. And the modes for the Indian unlisted company are right issue, MA, merger and acquisition, demerger, scheme of arrangements, bonus issue, capitalization of dues, or swap of securities. So unlisted Indian companies are eligible to make OPI by these modes. Now coming to the status of OPI. So it has been stated that OPI in the equity capital of a listed company, even after delisting, shall continue to be treated as an OPI until any further investment is made in the entity. Thereby, OPI, once an OPI will remain the OPI until and unless any further investment is made in the foreign entity. Now, into this thing, like a type of an ODI will be treated as an OPI. That is, if the investment is less than 10% of the paid up equity capital of a listed foreign entity, then that investment will be treated as OPI and will not categorize under ODI segment. Now, we have spoke about OPI by Indian entity. Even the resident individuals are eligible to make overseas portfolio investment, and the modes for the same are direct investment, including reinvestment, right issue, bonus issue.
Hello. Shweta, carry on. Carry on.
Hello.
Please carry on.
Sure. So the modes of investment by a resident individual under OPI are direct investment, right issue, bonus issue, capitalization of dues, swap of securities on account of scheme of arrangement, gift, inheritance, right equity share, ESOP, and minimum qualification shares for holding any type of directorship. So these are the modes. What is the limit for the resident individual to make OPI? The limit is the LRS limit, that is USD 2.5 lakh per financial year. And in any case, they want to make more investment than $2.5 lakh, then they have to obtain prior approval from the RBI. Under resident individual investor category, there are certain ODI which shall be treated as OPI. So an investment of less than 10% amount of paid up capital, equity capital of a listed foreign entity by the resident individual will be treated as OPI and will not form part of ODI. Or any type of investment up to 10% without having any control in the paid up equity capital by way of sweat equity share, minimum qualification share, or ESOP, either in the listed entity or in the unlisted foreign entity, that will also be categorized as overseas portfolio investment and will not be treated as ODI. Now, we'll speak about the provisions with respect to disinvestment of overseas direct investment. So the Indian entities or are eligible to make this investment by way of transfer or liquidation, and transfer can be executed by person resident in India by way of sale of investment to another person resident in India or to another person resident outside India. And the other way of transfer is transfer by way of scheme of merger, demerger, amalgamation, or buyback. So specifically with respect to disinvestment by way of transfer, RBI have specified two conditions. The very first condition is no dues outstanding for receipt towards investment, equity capital and debt in case of 100% disinvestment. Further, transferor shall have stayed into the investment for at least 1 year from the date of making investment. So here it shall be noted that RBI has liberalized the conditions with respect to disinvestment and have given some ease to the Indian investors to make this investment. Further, in case of scheme of arrangement, RBI have given certain exemptions from these two conditions. So where the foreign entity is wholly owned by the Indian entity, then these conditions are not supposed to be complied with, or no change or dilution in the aggregate equity holding of Indian company is going to be done by way of disinvestment, by way of transfer, then even conditions are not required to be complied with. Here also pricing guidelines plays a very important role. So in case of transfer, arm length pricing shall be taken into consideration and shall be calculated on the basis of internationally accepted pricing methodology or as approved by the scheme. That is, in case of a scheme of arrangement as approved by the competent authority, then a valuation report is not required. Whatever price has been determined under the scheme and has been approved by the competent authority, that will be taken into consideration by the Indian entity. Now let's understand disinvestment by way of liquidation. So approval of the competent authority as per the law of India or the law of foreign country, as the case may be, shall be obtained. Further, the erstwhile regulations were silent on the liquidation. So they did not specifically specify any condition for the liquidation, that is disinvestment by way of liquidation. Now coming to the very important aspect for the corporates are always willing to know, that is the compliances, the reporting requirements, the obligations which are to be complied by the Indian investors. So the very first, like here we are speaking only about the key changes of obligation. So apart from the submission of share certificates within 6 months, repatriation of dues within the specified time period, RBI has added one more obligation on the Indian investors, and that is submission of Form FC. This form is a new form and they have asked to submit this form to obtain UIN, that is unique identification number, before sending any outward remittance or acquisition of equity capital, whichever is earlier. So Indian parties are supposed to submit this form before sending the outward remittance. Now the reporting requirements, the forms which are required to be submitted, here also we are speaking about the key change. So RBI has came up with a new form as mentioned, Form FC, and this is the replacement of earlier form, that is Form ODI Part 1 and ODI Part 3. So this form is required to be submitted by both investor, that is the Indian entity, and the resident individual. So reporting of investment at the time of sending outward remittance financial commitment shall be done. Reporting through this form, reporting of restructuring within 30 days of such restructuring shall be reported to RBI by this Form FC, both by the Indian entity and the resident individual. And in case of disinvestment, the said form shall be submitted within 30 days of receipt of disinvestment proceeds. So this particular form has certain sections which are specifically allocated for certain corporate action, that is restructuring, investment or disinvestment. And at the time of those particular corporate action, the companies or the resident individuals are required to submit that particular section to the RBI. The other form is the introduction of OPI form with respect to reporting of overseas portfolio investment. So this form is supposed to be submitted by the Indian entity, and it shall be submitted within 60 days from the end of half year, that is September and March. So this is a half yearly form and shall be submitted in case of investment or transfer of investment. Further, in case of overseas portfolio investment by way of ESOP, so here RBI has specifically said that this form shall be submitted by the foreign entity through the office or branch or subsidiary in India, or an Indian entity in which such foreign entity has direct or indirect equity holding. So this form is supposed to be submitted by the foreign entity through the Indian office. Now coming to the form APR. So this form was earlier also there as form ODI part 2, and now it has been just created as a separate form and has to be submitted by both Indian entity and the resident individual. So here RBI has given exemption with respect to submission of this form. So in case the person resident in India holds less than 10% of equity capital without any control or without any foreign commitment other than by way of equity capital, then the PRI is not supposed to submit the form APR. The other exemption is the foreign entity is under liquidation. Even in that particular case, the form APR is not required to be submitted by the investor. Here, one clarification has been issued by RBI, which was like majorly a question from the corporate entities. And they used to ask that if in case our foreign entity, that is our where we have made the investment, their accounting year end on 31st December, then on by what date they are supposed to make the submission of APR. So in and all, the APR last date of submission is 31st December every year for the concerned financial year. But in certain cases, foreign entity used to have the accounting year ending to 31st December. Then here, RBI have clearly mentioned that the submission shall be done by December end of the next year. So in case by December 2021, the financial year is ending, then the APR with respect to that particular foreign entity shall be submitted by the end of December 2022. So this clarification has been provided by RBI. So a very important, then coming to the late submission fee, the LSF, the very important provision under the reporting requirement. So in any case, if the Indian entity has delayed to make the reporting, then RBI has introduced the concept of LSF for the delay in reporting, and they'll charge some late submission fee in case the form has been submitted with a delay. Further, provided reporting has been made within a maximum period of 3 years from the due date. This means that the late submission concept will be applicable only in case the reporting, the form which has been delayed, has been submitted within the maximum time period of 3 years from the due date. And if the investor has crossed that limit, that is the 3 years, then this LSF concept will not be applicable. So that is all with the overall overseas investment framework. So any question or anything?
Yeah. Okay, thank you very much, Shweta. You have covered very nicely all the points. Now I will give few minutes to Manoj and Amit for a specific point, because I have received more than 35 questions and there are 20 questions already with us. So I will request any other thing which is important on a macro view, Manoj and Amit, you can cover. So Amit, I will start with you. So you just tell.
I think Shweta has done full justice to the subject. My compliments to her that she has covered 360 degree. I think we can come straight to the question answer because time is less.
Manoj?
Yes, sir. I think overall theme of the amendment or theme of the changes is to simplify the thing. One of the very important aspect is overseas portfolio investment side, which has got many clarificatory changes, and which makes, I think, investment outside India very viable for Indian, let's say, family offices or corporate houses who want to continuously invest. A startup investment is one of the very key aspect where investment can be then made by Indian persons. Then investment in the fintech companies or cross relationship between Indian fintech companies and foreign fintech company could be established. So these are the very key and important amendments which will ease the foreign investment. I think otherwise, Shweta has covered everything in very much detail. So I think we can go straight towards the question answer session.
Okay. So thank you very much. Thank you, Shweta. You have nicely covered, and the presentation was extensive. And all the participants, we will send this presentation to you. Now I'm coming to the directly to the with the questions. I have various questions, so I will ask. I think Ankit, you can lead the questions because these questions which are there. Now I'll start with this. Whether rules, regulation, and direction shall be read together in harmony, or one can justify refer either of them. Ankit.
I think all has to be read in harmony. And generally, master directions are more in sort of adding clarifications to what has been provided in the rules and regulations.
Okay, whether investment of more than the foreign commitment is allowed.
It is allowed, subject to requisite approvals.
Does overseas portfolio investment will also be counted in the foreign commitment limit?
No.
Any other view on Manoj or Sweta?
No, I think that she has very clearly said that portfolio investment is separate from ODI.
Okay. Limit of financial commitment is also applicable on resident individual.
For resident individual, the limits under LRS are applicable, not the financial.
That is 250,000 USD per year. That is the limit. And for individual body corporates, it is 50% of their net worth. So that these limits are applicable.
Ankit, just you convert your photo. I think your face. Yeah.
Ankit, okay. Yeah. Now it's okay.
Okay. Why investment made by entities in Ifsc is exempted from the purview of OI regulatory framework?
Sir, it's not exempted. There are specific set of exemptions, like a financial institution in FIC. If it's invest, then it is not under OI. But if because entities in IFSC are treated as foreign jurisdictions, so investment in IFSC will be treated as overseas investment and will be subject to the relevant provisions.
Amit, do you have any view on this?
I'll agree with definitely, because government has a intention very clearly to promote and support IFSC, and they have brought many more exemption in the other various laws also. So this is in alignment to the same. This is not in distinction.
Okay. Can a non-financial sector India entity make ODI in the financial sector foreign entity?
It can make. There are now certain criteria of 3 years of profit, and they cannot make investment in banking and insurance sector except health and general insurance, subject to some regulations. But they can make, but they have to have at least 3 years of profit requirement.
Okay. Is it mandatory to route all transactions through the single AD bank?
Yes.
Manoj, why they have changed it?
It is not changed. Since beginning, it is you have to create one UIN number, and through that only you make investment. So that there is a tracking. It makes the tracking easier for RBI for all regulatory purposes.
Okay.
But Manoj, UIN can be still be tracked. Even if AD bank is different, then it should not make a difference, because ultimately the identity numbers remains the same. But I'll have to check.
RBI generally always promotes, specifically in case of ODI, that you should select one AD bank to route all these transactions. I agree that even if it is being made through other AD banks, still it can regulate and monitor, because the reporting requirement will still be there. But I think due to some internal issues or internal SOPs, they have mandated such things.
No, the purpose is that whether if, let's say, one person is making investment and there are certain lapses, which is known to one AD who is regularly in touch with the corporate or investor, then allowing shifting to another for ease and for avoiding those complications becomes become a practice. So they want to regulate that, and because it is the first touch point, they want it to be one person only. If you have a problem, you can specifically shift your entire account to another bank, and that may be allowed.
Okay.
Pawan, one small submission, but RBI, the regulation itself clarifies that it has to be through a designated authorized dealer. Even if more than one person is making investment, it has to be again only through one designated bank. So the two entities they have real relationship with two different banks. Even then, it is only through one bank only.
Okay. That's a good point. In case investment made by Indian companies in listed foreign companies reduced from 10% limit, whether status of such ODI will be shifted to OPI or will remain the same?
Sir, in case of either OPI and ODI, the status will continue to remain same even if the situation or the characteristics have undergone change. If they are made as ODI or as OPI, they will continue to remain as such unless and until fresh investment is being made.
Okay, Prashad sir, wherever you think that
I'm listening.
value.
I'm listening.
Yeah.
And I think the presentation was very good. It covered 100% in their directions well. Yeah. That's why it is.
Okay.
I will add whenever I feel if anything needs to be added.
Mere percentage of voting right will result in control, or other aspects are also be considered collectively, Manoj?
So I think we have discussed the 10% investment is just one of the mode. The key test is the control here.
Okay. In case of investment in Indian company by foreign entity, round tripping number of layers to be counted from the foreign entities or the Indian entities?
I think this was raised as a question by Sweta, but clearly they want whatever is in India. So if the foreign company has, let's say, 3 layers outside India, and then they come to India, and then there is only 1 layer, then I think there is no problem. It is only because this question is arising from the round tripping provision, which is when money from India is going out and coming back to India. So then only it will be a question of round tripping. So that is very clear. I think there should not be any confusion.
But I think some clarification will still required, and there is a lot of discussion on this point. And while they have mentioned the 2-layer restriction, if it can be very provided just a word in India or otherwise, so then it will simplify the entire process.
Okay.
Right. Actually, round tripping is always a very complicated subject. It was never in the books of law anywhere, but it was well settled position that you cannot invest Indian money going out and coming back to India. So that was not allowed. They have not mentioned anywhere in the regulations earlier. Now they have clearly mentioned. So I think next step will be one clarification to avoid these confusions.
Okay, in case of disinvestment by way of a scheme of arrangement approved by the competent authority, what will be the pricing guideline, Manoj?
Sir, this is in case it's a scheme of arrangement, there will be swap of shares. So it now, as per the Indian company law as well as RBI regulation, cross-border mergers and acquisitions are allowed, where Indian company can be merged into company outside India or vice versa. And in all such cases, there will be swap of share. And swap of share is for Indian company, it has to be determined by registered valuer registered with IBBI. So that will be the test from Indian side. And for counter side, there may be requirement of some investment banker or CPA as per the regulatory requirement of the jurisdiction. So that will be the swap ratio, and it will be approved by competent authority, that is NCLT in India, and similar jurisdiction if required as per the outside Indian regulations. So that will be sufficient.
Okay. In case of, can Indian company directly fund to step down subsidiary, Ankit?
Yes, I think there is no such restriction.
Equity investment is allowed, but direct investment in the form of loan is not allowed. I think
that's not allowed to SBI. That is the case.
Direct loan cannot be given unless equity investment is there.
Okay. Whether remittance done from resident foreign currency account to be treated as ODI?
No, it is outside the purview of ODI regulations because there is no outward remittance from India. It's foreign earned money remaining in foreign account.
Okay, whether resident individual is permitted to transfer ODI by way of gift to person resident outside India?
2%. There are provisions with respect to transfer receipt of resident by person resident in India. There is no specific provision of transfer by way of gift. Shweta, is there any such provision?
So earlier there was no such provision. However, in the current framework, RBI have specifically prohibited any of the person resident in India to transfer overseas investment by way of gift to a person resident outside India. So there is a complete prohibition.
Okay. Whether resident individual is whether the sale proceed of overseas investment are required to reparted or can be reinvested?
I think new provision of reinvestment has come. Clarity has been made.
Okay. Shweta, what is the last date for submission of APR if the overseas entity financial year ends on 31st December?
Yeah, so in general, APR last date is 31st December. And even in case the foreign entity financial year ends on 31st December, then the next year, 31st December, will be the last date for the APR.
Okay, okay. If group of the Indian investor has invested in the same foreign entity, whether APR to be submitted by every investor separately?
APR can be submitted by an Indian investor who is having the maximum stake. So separate APR is not required. One can be submitted jointly.
Okay. Whether form APR and FLA to be submitted by resident individual also?
APR is required to be submitted. However, FLA is not required to be submitted by resident individuals.
Okay. If investment by resident individual is less than 10%, whether APR will be submitted?
It is exempted clearly by the RBI in the current ODI framework.
Okay, Shweta, whether the reporting will be made to the AD bank or RBI?
Every reporting will go through the AD bank to the RBI. So AD bank will be reported by.
So through AD bank to RBI, okay?
Correct.
If no transaction regarding ODI has been undertaken in the current financial year, whether reporting of APR and FLA is required?
Yes. So it's the annual compliance, not an event based. So you have to report APR and FLA every year till the time you have the overseas investment.
Okay. Whether reporting of establishment of step down subsidy is required to be done?
Yes.
Okay. Ankit, now I have 45 more questions. So I will just read 5 initially. Can a global MNC place a fixed deposit with the gift IBU offshore unit of the Indian bank and seek fund-based and non-fund based limit with the AD bank, Indian bank operating in India?
There has to be some connection between the entities, because an Indian entity can create charge on its assets for foreign subsidiaries or SDS, and similar is the inverse relationship. So if that's the case, it can be done.
Okay, okay. Okay.
That clarity has been made. Earlier, there was no clarity whether foreign assets can be placed or mortgaged to raise money in India. That was not clearly mentioned. So it was a difficulty. Now it is clearly mentioned. That's a good thing.
Okay. I have invested in unlisted equity share from foreign currency bank account abroad.
So as I mentioned, it will not be covered under ODI.
Okay. Would the LRS limit of US dollar 250,000 apply for individual looking for investment in investment revenue in IBU listed security made available in IBU ODI in the IBU? Manoj?
Yes, LRS limit will be applicable, 2.5 lakh rupees, US dollar every year.
Okay. Okay. Team is correct. Is it correct to understand that the new law amended always allows the Indian resident to invest in a foreign entity as long as the foreign entity has only one subsidiary in India, that is a foreign entity does not have more than 2 layers of subsidiaries in India, either directly or indirectly?
So yes, it is true. Up to 2 layers of investment subsidiaries can be there. In India, outside India, that is a point of discussion. But yes, there is a restriction. If there is a breach in the number of layers of subsidiaries, then there are certain restrictions on investment.
Okay. I have invested in unlisted entity shares from foreign currency bank account abroad less than 10% of equity share of the company. Is above amount is covered in ODI of foreign equity investment? No.
It's outside the purview.
Okay. I have a question. Why the relevance of OPI in case of unlisted foreign entity? What is the relevance of OPI?
So in certain cases, in unlisted foreign entities, if you acquire shares like on account of sweat or on account of ESOP, it's less than 10%, they will continue to be treated as an OPI. Otherwise, all other investment will be treated as ODI.
Sir, generally investment outside India was allowed earlier only in wholly owned subsidiary or joint venture. So there is a relationship of control that is not there. If that is not there, then it is overseas portfolio investment. So earlier portfolio investment was allowed only in case of listed company where trading can be made. But now, because there are a startup culture, there are people are getting ESOPs and other shares which are very minuscule in value size, but can have substantial value. So that is allowed now for a specific purpose.
Okay. Okay. Will these changes affect remittance made under LRS to self, foreign bank account, and creating fixed deposits overseas?
No, they will not have any impact.
Okay. After these amendments, can I transfer fund to my own foreign account and create fixed deposit from there? Is it necessary to repatriate the interest, or it can get accumulated overseas?
So this has no relevance with the ODI regulations. You have to refer to the LRS master directions.
Okay. What is the changes with regard to valuers? Whether registered valuer are now eligible to get valuation report under ODI rules? Manoj?
Yes, in certain cases they can.
Okay. We will share this presentation to all. Definition of startup.
So startup is defined as recognized under relevant laws. Like in India, we recognize startups by way of registration with DPIIT. So in host countries, if there are any provisions of recognizing such startups, and if the company in which you are investing or supposed to invest is registered under the relevant regulations identifying startup, then your company will be treated as a startup for the purpose of the regulations under the ODI.
Okay. Okay. ABC Limited has one group company XYZ in UAE and PQR subsidiary of XYZ in UAE. PQR does not have fund for taking office premises and want to take loan from ABC Limited. Is the transaction is permissible?
No, it is not permissible. Loan can only be granted to the subsidiary, a foreign entity, not to the SES, unless and until the company have any equity holding in that entity.
Yes, you have to create a shareholding structure first. You have to put money in equity, whether 1% or so, and then you can make loan.
Okay, I believe 10% is correct as it was joint venture, wholly owned subsidiary concept is earlier ODI framework. 10% is just a criteria now.
Yes.
Somebody.
Yes. Yes.
Achha. Any exemption from 400% limit of ODI is made from EEFC account like in previous regime?
I think
foreign currency account. Exchange and foreign currency account investment.
Shweta, what is your view?
So utilization of the funds in the EEFC account will be counted under the financial commitment, and that has been specifically mentioned under the new framework by RBI.
Okay. Please elaborate regulation 12, delay in filing. Whether will be it considered as a delay? What is the case of first ODI remittance?
So, like sir, first ODI remittance, now the rules are very clear that before you undertake the remittance, you have to file the Form FC with the AD bank, and only after that you can undertake a remittance. So if you undertake even the first remittance and you have not filed the form, first of all, I don't think OD Bank will allow the remittance unless it will be filed. But even in case there is a lapse at the end of OD Bank also, AD Bank also, and you filed it without filing ODI, then after the prescribed timelines, the late fees will be triggering.
Okay. Okay. The limit of investment in case newly incorporated in India is this scenario. There is a no provision previous audited financial. Please clarify.
So the query is not clear.
The limit of investment in case newly incorporated in India.
If Indian company is making
in any case, the limit will apply.
Okay. So, sir, foreign investment is not allowed. Portfolio investment would not be allowed for a newly formed company. FDI can be, ODI can be made by within the limit of 400%. So, auditing would be required. Limits are applicable.
Mr. Suniljan, your queries are very long. We will give you separate reply, and this is a multiple things. So, speaker will be confused. So, I will send you separately. Is approval from certain central government is required in case of investment in any startup?
No. Unless and until central government prescribed by the rules, as of now, it is not.
Okay. If an Indian parent use a CG on behalf of its second label subsidiary company, will it be under the automatic route or approval route under the revised regulation?
It will be in the automatic route. You can provide the corporate guarantee to your step-down subsidiaries, subject to compliance of the relevant regulation.
Okay. Whether only one framework need to be read as a whole for ODI framework, as earlier LSR scheme was a separate regulation.
So that is the confusion that was there. I think with the new regulations, RBI has ended all these confusion. So any kind of investment, whether if it's an ODI or OPI, it has to be governed in terms of the regulations by the ODI rules and regulations and by the limits by the LRS limits.
Okay. I as a promoter of Indian company want to make investment foreign unlisted company within the limit of 10%. Can I make investment into foreign unlisted company with overall limit of LRS?
Yes, you can. You can, subject to the regulations given therein, you can.
Ankit, please speak clearly.
You can do it, provided it is engaged. It's a non-financial sector entity, engaged in bona fide business and doesn't have any subsidiary or step-down subsidiary. You can do it.
Okay. Can an individual make investment in a foreign entity under LRS scheme in equity and redeemable preferentials?
In redeemable preferentials, I think investment is not allowed. I think investment is only allowed in equity, and it has to route it through ODI regulations only.
Okay. Can an Indian entity transfer ownership to step-down subsidiary of its only owned foreign subsidiary to a resident Indian?
There is no such restriction.
What about if different Indian entities hold equity, whom file APR?
That I think Shweta has already clarified.
I will repeat again.
Who holds the maximum percentage shareholding?
Okay. What will happen if delay is more than 3 years?
I think then you need to go for compounding. Shweta?
Yes, it will be under compounding.
Okay. Can a resident individual make subsidiary of or SDS of a foreign entity?
No.
Okay. How has the LSF been defined?
Late fees.
Late submission.
Yeah. Late submission.
I think there is a specific formula in the master direction.
When the specific formula into the master direction to calculate the same.
Okay. Okay. In one entity, can an Indian parent give loan to a 100% foreign subsidiary to buy Indian listed subsidiary of the parent?
Indian listed subsidiary. There is no debarment, but this is important transaction when we need to evaluate. There is no express bar.
Some questions which Ankit is and you all are giving, if any things we have to clarify further, we can clarify to the.
I think for it is a direct round tripping transaction which would not be allowed. It is the relaxation is that you can invest in a foreign company who has invested in an Indian company, but the purpose of investment in foreign company cannot be to invest back in India. So that cannot be allowed.
And in the presentation, this prohibition has been specifically mentioned that investment proceeds shall be utilized only for the purpose of core business activity of the foreign entity and not for the purpose of investing back into India.
Yes.
Okay. Is there any foreign entity, we have 5% investment and also providing FC through debt. Now we need to increase the percentage holding of 10% or make further FC in the entity.
Yes, you have to acquire control in one way or other to give more debt or non-fund based.
Okay. Can I sell a property purchased in overseas, purchased through LRS without permission of RBI?
LRS is allowed for purchasing property outside India. That is not prohibited.
No, he's saying, can I sell a property purchased in overseas, purchased through LRS without permission of RBI?
Yes.
Okay. For new ODIs existing foreign entity, we need file from ODI to or FC. Shweta.
FC.
We have to file from FC.
Okay. Okay. the very insolvent due to connectivity issue between unable to follow few areas would like to share. We will send the recording. Don't worry. Okay. Liberalized network framework for deferred consideration and write-off applicable to wholly owned subsidy, and we understand the step down subsidy. No such stringent condition applicable for deferred consideration and write-off. Anybody?
So, with respect to deferred payment, RBI have earlier in the earlier ODI framework, it was under the approval. So RBI have dispensed the approval, and deferred payment can be done under the automatic route itself.
Okay, we have overshoot the time, so I can just can I few question I'm taking, then rest of the question we will reply through. Ankit, please reply all the questions which are coming late. I'm taking 3 more questions. Can IT company India engage in BFSI support service outside India? Can it be allowed? If not, what is the implication under new regulation?
So if they want to undertake investment outside India, they can.
Okay. If AD Bank is to be changed due to unavoidable reason, how to cope up?
Shweta, any specific process for this? I don't think.
No, there is no specific process, but the Indian investor shall make sure that it has all the reportings copy, like they shall have the record of the reporting, so that in future they will not have any issue, or they don't require to go back to the previous AD Bank to get the same.
Okay. Okay. The last question is obtaining the gifted shares from NRI to whom ODI regulation is not applicable to be deemed as compliance in provision of ODI.
Yes, you can. Person resident in India can take gift from person resident outside India.
Okay. Okay. So I think there are few more questions which are coming continuously. We will, some of them are suggestions, some of them they are giving thanks. So what we will do, the remaining question which are left out, we will share through email. So friends, it's a time to close this session. Thank you very much, Prashad sir, joining, Amit, Ankit, Manoj, Shweta. Shweta, you have done wonderful job today, and you have explained very well and very lucid presentation which you have given. So thank you very much. Friends, this journey of knowledge sharing will continue. Today, I'm in Calcutta, and we are addressing from Calcutta, me and Ankit, but this thing will continue. So our next topic which we are doing, that is settlement scheme. As you are aware that SEBI has come out the settlement scheme, and in the settlement scheme, this is a revised scheme of which Manoj has explained to you, that 14,000 notices issued by SEBI, and we will cover up these all topics, all aspects, all points relating to that settlement scheme, that why this, how this scheme will work, what are the important points, what are the important things you have to take care of, taxation aspects and other regulatory aspects, and how to do this and how to make compliance. So next Friday, we are covering this. So thank you very much to all for joining, and thanks all my speaker. Thank you.
Thank you.
Thank you. Thank you.
Thank you.